So New York is stalling the case, which requests that the Supreme Court take review away from the lower courts and decide the New York new concealed carry law right here and now. So let's talk about this. But real quick before we jump into this video, I want to thank the sponsor of this video, which is Kershaw Knives. Kershaw produces a broad range of knives to meet every single person's needs. I really enjoy their knives. I use one of their knives every single day for my EDC. And currently, Kershaw actually dropped their new 2023 line, which includes a new line of knives, including a US-made automatic knife. So I highly recommend Kershaw Knives, and if you go to their website and order using the code 20Scholar, you can actually get 20% off of your order and also free shipping on orders of $100 or more, and that offer will last until May 1st. So head on over to Kershaw Knives, use that code, and thank you again to Kershaw Knives for sponsoring this video. As I mentioned in the intro, in this video, we will be discussing a case that is now asking for the Supreme Court to take review power away from the lower courts and instead review the New York concealed carry law and that New York Concealed Carry Improvement Act right here and now on their own. The case we will be discussing in this video is called Gazzola v. Hochul. This case involves a challenge to the state of New York's new Concealed Carry Improvement Act, which was passed in direct defiance to the Supreme Court's recent decision in New York State Rifle and Pistol Association versus Bruen. This case is different from some of the other challenges because this case focuses on the impact that the CCIA has on dealers and gun stores as well. These businesses argue that the CCIA is unconstitutional because it violates the Second Amendment and also that Bruen decision. The businesses argue that they are a critical component to the right to keep and bear arms, and that the CCIA attempts to regulate these businesses out of existence. In response to this law, the plaintiffs filed a writ of cert before judgment up to the Supreme Court, and New York, in response to all this, continues to stall that review by the Supreme Court, saying that they are not yet ready to actually defend their unconstitutional law. This whole case is a result of the Supreme Court's recent decision in Bruen. In Bruen, the Supreme Court struck down New York's May-issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. One of the primary findings of Bruen in that decision was that the government bears the burden to prove that their restrictions are based in the history and tradition of our nation. However, despite that decision, New York rushed through the Concealed Carry Improvement Act, also known as the CCIA, which made the permit scheme in the state of New York even worse than the one that existed prior to Bruen. But all this also had major impacts on gun stores within the state of New York. These businesses, for example, are challenging how the CCIA's regulations are currently preventing them from being able to sell specific firearms. They claim that their entire inventory right now are being trapped because of this law. They are also challenging the CCIA's ammunition background check requirement, and they are claiming that all these additional restrictions on their businesses are creating drastic drops in their sales, which obviously is causing them significant injury. In the case, the plaintiffs sought to obtain a temporary restraining order and also a preliminary injunction from the district court. However, the district court rapidly denied both the TRO and the preliminary injunction in the same order. The plaintiffs then submitted an interlocutory appeal up to the Second Circuit. The plaintiffs sought for the Second Circuit to find that the denial of the TRO and also the preliminary injunction was in fact an error. However, a three-judge panel in the Second Circuit denied their appeal, saying that the court weighed the applicable factors, and the court there found that there was no error by the district court. That then led the plaintiffs here in this case to filing an emergency application up to the Supreme Court to essentially stay the decision of the lower court. That emergency application was originally filed to Sonia Sotomayor, who then referred that emergency application to the full court of the Supreme Court. Recently, the full court of the Supreme Court denied that emergency application. However, something else developed along with this case, and something else went up to the Supreme Court. Instead of waiting on that emergency application, the plaintiffs also in this case submitted a petition for a writ of certiorari before judgment. This is a completely different mechanism, and it's also a very rare mechanism. This mechanism is essentially a way to bypass hearings and rulings at the lower court level and instead go directly to the Supreme Court for an actual ruling on the merits of the case. Under Supreme Court Rule 11, the Supreme Court can, any time before judgment, deviate from the normal appellate practice to review matters of such imperative public importance as to justify immediate determination in this court. And that is what the plaintiffs here are seeking in this Gazzola case. They want to bypass the lower court hearings and instead have the Supreme Court rule on whether New York's CCIA law is indeed constitutional or is it unconstitutional because of how it impacts firearms dealers within the state of New York. Now, originally, the Supreme Court had set New York to respond to the cert by February 8th, but New York has now requested an extension of time for that response twice in this case, and recently they just received another extension from the Supreme Court. In the recent request by the state of New York for an extension, they stated, "I write on behalf of respondents to request an extension of time to oppose the petition for a writ of certiorari before judgment in this matter. The current deadline, after one extension, is March 10th, 2023. Respondents respectively seek an additional extension of 31 days until Monday, April 10th, 2023 to file an opposition. This extension is necessary because of the press of work in previously assigned matters requiring the attention of the attorneys most knowledgeable about this case. An extension is appropriate for the additional reasons that the appeal in this case will be argued in the Court of Appeals on March 20th, 2023, and that argument may be relevant to the petition for a writ of certiorari before judgment. Petitioner's counsel has informed me that petitioners do not consent to this further extension." So here, the state of New York is arguing up to the Supreme Court that they need additional time to file their response up to the Supreme Court in this case, because essentially the attorneys who are going to defend this case are busy defending other cases, and also because a hearing will take place on March 20th on this very issue. Therefore, the state of New York argues they should get an additional extension of time, which would mean that they would not have to file their response up to the Supreme Court until April 10th. Well, the Supreme Court, in fact, did respond to this. They just issued their order, and they granted an extension in part, but only gave New York until March 29th to file their response. What I think is happening here is the Supreme Court is holding off until the consolidated preliminary injunction hearings can actually take place before the Second Circuit Court of Appeals. The Supreme Court appears to be giving the lower court here, the Second Circuit, one last chance to actually get things right. And the Second Circuit recently consolidated an expedited review of 6 of these cases, 6 challenges to the CCIA, including one of the challenges down below to the Gazzola case. So because of those developments, I think the Supreme Court is holding off until they actually see what the Second Circuit is going to do and whether or not the Second Circuit there actually took their warning seriously. Right now, I don't think the Supreme Court is ready to outright strip review of this case from the Second Circuit, but if the Second Circuit does not actually do the right thing after that March 20th hearing, I think there is the potential that the Supreme Court could step in and maybe grant the writ of certiorari before judgment. But I wanted to bring this to everyone's attention again, bring this back onto everybody's radar, because this is something a little bit different and it involves kind of a more novel Supreme Court mechanism. It also is kind of setting up the groundwork for quick review by the Supreme Court if the Second Circuit does not properly review those 6 CCIA cases, which are set for a hearing on March 20th. So right now, the Supreme Court has held off review of the Gazzola case at the Supreme Court level, and all eyes will be on the Second Circuit to see what they do. But if we get any more information, of course, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.